case of Yickwu versus Hopkins of 1886. In this case, the city of San Francisco, California, enforced a particular criminal law against hundreds of Chinese Americans, but against none of its non-Chinese citizens. Now, how many of you think this is fair? How many of you think that it's unfair? Okay, it's unanimous, and this time the court agrees with the audience. And yes, it was held to be unfair, and therefore all of the convictions of those many Chinese Americans were overturned. Okay.
Just wait till World War II.
Okay. And our next case is the case of Plessy versus Ferguson of 1896. In this case, the state of Louisiana had a law which required that African Americans and white passengers ride in separate railroad cars, although it claimed that the quality of the two cars was equal. How many of you think that this is fair? How many of you think that it's unfair? Okay, from a modern perspective, that's how we feel. At this time in our history, the Supreme Court decided that separate but equal is fair. Okay, any further discussion about this case? Very good. And our next case is the case of Korematsu versus the United States of 1944. During World War II, Japan bombed the United States military base at Pearl Harbor, Hawaii, and the United States went to war against Japan. While at war, the United States relocated many American citizens of Japanese descent and placed them in internment camps. Often these citizens were separated from their families and were mistreated, and some died. Okay? Anybody want to argue that this is fair? How many think that it's unfair? Okay, very good. And that is by far the overwhelming opinion today. During the wartime, how do you think the court came down? Well, it did indeed oppose this relocation and internment, and this has been to much criticism. I will say, however, that, and there are some very important howevers, many of the people that initially supported this decision, when they saw the impact and saw that its effect, many of them actually turned against their own initial belief that this was a good thing to do, a right thing to do. And in fact, the United States later on ended up paying reparations to those survivors, but it was decades later. Unfortunately, many of them had died. So unfortunately, some of them got nothing, and most of them who got something got it much later, and it wasn't really, financially, what it should be, but it was something. But there is a very important, however, that even some of the supporters, the strongest supporters, ended up realizing what a terrible mistake. Yes.
I just wanted to share a personal experience. My mother I actually had great-grandparents living out here at the time, and my mother was out visiting with them, staying with them, and going to school at LACC. This is in 1941, and she remembers them cordoning off the streets, and she remembers all the, suddenly there were no Japanese children walking the streets to school that she had seen every day.
Right.
Quite a memory to hear them.
Steve, having lived through that myself, let me tell you, at the time it was very popular, the decision of the Supreme Court. Years later, most people came around, but there were just a few of us who really opposed it back in those days. And it took a little courage to oppose it. Not very many did.
By the way, this case illustrates a couple of concepts that are important in equal protection. The concept of over-inclusiveness and under-inclusiveness. This classification is over-inclusive because it includes many thousands of people who would have been completely loyal just because perhaps a very small percent, less than 1% of the Japanese Americans would have caused the problem. Greater than 99% would have not caused any problem at all. But it included all the Japanese Americans, so it included tremendous number of people that were completely not in need of doing this relocation and internment. So that's over-inclusive. It's also under-inclusive because there are a small number of people that would have been disloyal to the United States that were not Japanese. Perhaps some of them might have been from the countries of national origin, from the countries that we also fought against, such as Germany or Italy, but perhaps some of them could have just been any other particular background, that just for whatever reason would have caused a problem during the war. And so it did not include anyone else who's disloyal other than all Japanese Americans were presumed disloyal. Now, usually when there's a large extent of over-inclusiveness or under-inclusiveness, usually, at least in future cases, that's an argument to say that there's an equal protection violation, and usually the courts will listen. Unfortunately, those arguments, did not prevail in this particular case. But over-inclusiveness and under-inclusiveness is a very important concept in future cases, and it leads to a lot of rulings where things violate equal protection because they're too over-inclusive or too under-inclusive. Okay? Yes, Jeff?
I just wanted to say, I think that was a really good point. When you brought that up, it really kind of put a different spin on it and really clarified it. So I just think that was very helpful.
Well, thanks. And in fact, yeah, you see those very words in some of the future Supreme Court cases. This classification is over-inclusive and or under-inclusive, and therefore it violates equal protection. So, okay. Our next case, a very famous case of Brown versus Board of Education, 1954, in which several states had separate public schools for African Americans and for white students. Now, it was claimed that this was fair because the two schools were said to be equal in quality. Now, this sounds very much like Plessy versus Ferguson, doesn't it? Separate but equal railroad cars in one case or public schools in another case. But this is the year 1954, decades after Plessy was decided, so the court revisited the issue. How many of you think that it's fair? How many of you think that it's unfair? Okay, everyone. And anyone want to comment? Okay, it's a very famous case, and on revisiting the issue, the Supreme Court determined that it was unfair, and today the courts, generally rule separate but equal unfair in any context, whether it be public schools, transportation, or anything. So it's a new realization that separate but equal is not really fair. And oftentimes they claimed it was equal and it wasn't really equal. But that aside, assuming that it was equal, maybe even assuming that one is better, it doesn't matter. It doesn't matter because separate is wrong. Just the separate part is wrong. And so this began a process of desegregation. Okay? Any further discussion about this very important case? Okay. Let's move on. The next event, before we get on to other cases, was a very historic speech, the I Have a Dream speech by Dr. Martin Luther King Jr. on the steps of the Lincoln Memorial in Washington, D.C., before thousands of supporters. You can click on it any time. It might take just as long to download, perhaps. We'll see. But we're going to see just some very small excerpts of the speech. Yes.